All right, we're going to go ahead and get started. We've got a lot to cover today. Good afternoon, and thank you for joining us for this special COVID-19 webinar, Confronting Employment Issues, which is hosted by the Birmingham Business Alliance, Maynard Cooper Gale, and the Birmingham Regional Economic Development Alliance, which is a network of economic development professionals and organizations throughout the 7-county region. My name is Lauren Cooper. I am Vice President of Communications for the Birmingham Business Alliance, or the BBA, and I'll be moderating today. Maynard Cooper, the BBA, and all of our economic development allies in the surrounding counties have been working pretty tirelessly one-on-one with impacted businesses during the pandemic and have established response teams, task forces to answer questions and address issues facing local businesses during this challenging time. From the BBA perspective, we're currently reaching out to more than 500 of our investors that we have identified as small to mid-sized businesses that'll most likely be impacted by the pandemic. We're offering support and connecting them with the resources that they need when it's appropriate. And we've provided a lot of guidance to a lot of companies on SBA loan programs. In these conversations, we and our allies have had with these businesses, we received a lot of questions that are legal in nature. So we turned to our partners at Maynard Cooper Gale, who have also been working tirelessly with their clients and small businesses. And in looking to them, to their expertise, we decided to partner on this webinar to address some of the more frequently asked questions that we were all getting and to help us understand what will be most important for businesses as we return to the workplace. A lot of these questions were around labor and employment, which is the focus of our webinar today. A little on the structure of this meeting. We have 5 important topics to cover with a lot of information covered by 4 labor and employment attorneys. We'll give them each about 10 minutes to address the topic and then cover the questions that we've frequently most been asked in the hopes of wrapping up right around 3 o'clock. If any of our attendees need clarification on something that's been discussed, or if they have a follow-up question, they can visit the COVID-19 response page on the BBA's website and then click on the Ask a Question tab, and we'll follow up following the webinar. So I want to give a brief background on the speakers today. We have with us John Holmes, who is chairman of Maynard Cooper's Labor and Employment Practice. He represents management and advises clients in a wide variety of EEO and labor and employment matters, including cases arising from FMLA, FSLA, Title VII, age discrimination, ADA workers' compensation, and other state discrimination and tort laws. Welcome, John.
Thank you.
Next, David Block is a labor and employment attorney who has served some of North Alabama's largest employers. He advises clients on employment policies, employment discipline and termination, harassment training, reductions in force, and wage and hour issues, with a focus on manufacturing, distribution, defense industries, and serious workplace accidents. Thank you for joining us, David. Josh Bennett represents and guides clients across a broad range of EEO and labor and employment matters, including employment agreements, non-compete agreements, grievance proceedings, and labor arbitrations. Welcome, Josh.
Thanks,
Finally, we've got Brock Phillips, who assists clients with all types of labor and employment matters, including Title VII issues, age discrimination, disability claims, FMLA, FSLA, and whistleblower statutes, including Sarbanes-Oxley. He's been heavily involved in the Maynard Cooper's research and distribution of COVID-19 legislation and guidance. Glad to have you with us, Brock.
Thank you, Lauren.
So I'm gonna, with that, I'm gonna turn the program over to our experts. First, we'll talk about the Families First Coronavirus Response Act with Brock Phillips.
Thank you, Lauren. I'll go ahead and speak for everyone and just extend our appreciation at the opportunity to do this. We're very excited to have this opportunity from the BBA to kind of share what we've been able to learn over the past month in very rapidly changing environment. So I'm gonna, as Lauren mentioned, I'm gonna speak on the Families First Coronavirus Response Act, which I'm just gonna refer to as the FFCRA, because I only have about 10 minutes. The FFCRA is a federal law that was passed by Congress in response to this COVID-19 pandemic that we're kind of right in the middle of right now. So kind of in a very brief nutshell, what it does, it provides employees with federally mandated paid sick leave for COVID-19 related reasons. I think a lot of people on this call, since we have passed the effective date of the FFCRA, are kind of pretty familiar with the background, what the law entails, what it requires, what entitles employees to leave under that law. But I think it's worth just kind of overviewing that for a minute and then moving into more of what questions are we getting on this law and what are we advising our clients on their questions. I think everyone is pretty familiar with the law by now, but it provides for about 5 or 6 reasons that employees may take federally mandated leave under the law. So, when an employee is subject to a governmental quarantine order, kind of like what we have in place in Alabama right now, our shelter-in-place order, when an employee goes to the doctor and the doctor says, hey, look, you need to self-quarantine. Either you have COVID-19 or you're particularly susceptible to COVID-19, it's best you stay at home. If the employee has symptoms, is looking for a medical diagnosis, or is caring for someone who might have COVID-19. And then, another one of the reasons we see probably more than others, if I had to put a number on it, is that when employees have school children at home, a lot of schools are being shut down, if not all of them. And so if an employee has a kid at home because that child's school has closed because of COVID-19 or because childcare is not available for COVID-19 reasons, that's going to entitle the employee to leave under this law too. Now, one very important thing to keep in mind about all these reasons for leave is that they have to prevent the employee from being able to work. It has to keep them from coming on site to the extent employers still have their on-site employment, or keep employees from being able to work at home. If they can work at home, if they can still go on site, they're not going to be entitled to these leave benefits. Now, for some parts of some of these leave reasons, employees are going to be entitled to their regular rate of pay. For other reasons, it's only going to be 2/3 of their pay. So keep an eye on what the specific reason the employee takes leave for. So that's kind of a very, very high overview of what the law entails, what it requires, and what entitles employees to leave under it. I think probably the best use of my remaining time is going to be to go through some of the more frequent questions we've gotten over the past month on that our clients are asking us as to this law's application. And one of the first questions and most frequent questions we've gotten is, hey, how are we going to afford this? This law applies to smaller employers, and smaller employers don't always provide for paid sick leave benefits for their employees. When they're making the budget in January and February, this is not something that was on anyone's radar. So this is kind of a new expense that quickly came up. Congress had that in mind, at least to some extent, when they were drafting this legislation. So I'm going to oversimplify it a little bit, but for every dollar that an employer pays out in these FFCRA benefits to its employees, it can withhold $1 that it would otherwise pay to the IRS in its Social Security taxes that it pays on a quarterly basis. Now, this is not something that the employers have to pay these taxes to the IRS and then go through the process of seeking reimbursement. This is something they can just withhold on the front end. So that eases some short-term liquidity concerns that employers might have, though it doesn't ease them fully, as we know. And if an employer pays out more benefits than it would have paid to the IRS, you can seek a refund at a later time. This kind of segues into another really key portion of the law that we've spent a lot of time with, and that's documentation. Documentation is very, very important, as all employers know, for a number of federal, state, internal leave laws and policies that you have. It's important for the employee because that in many instances is what entitles the employee to leave in the first place, and it's important for the employer for a number of reasons. The FFCRA is certainly no exception to that general rule. The employee has to provide this documentation in order to be entitled to leave under the FFCRA, and the employer has to have this documentation in order to get those tax benefits. You know, if you want the government to pay for these benefits, albeit in this roundabout way, you have to have this documentation. Is this anything onerous? Not really. I'll briefly overview some of the documentation requirements that we have under the FFCRA. No matter the reason for leave under this law, you're going to need 4 things. And like I said, they're not very onerous. You need the name of the employee who is taking the leave. You need the dates for which they are requesting the leave, the specific reason under which they are requesting leave under the FFCRA, and then you need some type of statement from the employee basically saying, hey, look, I have this reason, FFCRA qualifying reason for leave, and because of that, I can't work. I can't go into work to my employer's place of business, and I can't work from home. Now, depending on the specific reason for leave, you might have further documentation requirements. I'm not going to get too much into the weeds on that, but know that depending on the reason for leave, there might be further requirements than what I named. Now, there's no real hard and fast guidance on what this documentation looks like. I think we've been telling people, think to what you do already. Think to your FMLA documentation. Think about your internal leave policies, that documentation. And for administrative ease and purposes along those lines, it's easy just to put it in one form. We've been doing that over the past month for clients, just kind of putting all the boxes you can check and lines you can fill in information and signature lines and making that easily administrable and uniform. And make sure you hold on to this documentation too. The IRS, the DOL, they've come out with guidance that you need to hold on to this for the next 4 years. So now we're kind of past at this point all the learning about FFCRA leave and getting your policies and forms implemented to a certain extent. Now we've got to start thinking about what it looks like when employees are on leave and when they're finished with the leave. Employees under the Emergency Paid Sick Leave Act portion of the FFCRA get 10 days of paid leave for the reasons I covered earlier on in the presentation. But what happens when those 10 days are up? I think the first thing you need to do is you need to look to see if under the FFCRA, they're entitled to more leave. For the reason I mentioned about school children being home because their school is closed or because childcare is unavailable, that has the potential for an employee to be entitled to 10 more weeks of paid leave under the expansion of the FMLA that we have in the FFCRA. It's also important to remember that while we're very focused on the FFCRA right now in the world of employment law and specifically in federal leave law, it doesn't do away with everything else that we're used to dealing with in years past. You know, the traditional FMLA analysis is still going to apply, and something we really need to think about when an employee exhausts his or her FFCRA leave. There's going to be a big overlap between employees who are out for COVID-19 related reasons and employees who may, even after their 2 weeks off of work, who may have a serious health condition under the traditional FMLA analysis. So in addition to that, be thinking about the ADA disability analysis, be thinking about any state law leave obligations that you might have. That's not something we necessarily think about as much in the state of Alabama since we're kind of low on state leave laws, but to the extent you have employees elsewhere, think about that. We're going to hear from my colleagues later on about some of the practical considerations when employees are coming back to work. Those are certainly things to keep in mind as well. I know Lauren's probably going to cut me off here in about a minute more, so I'll try to quickly cover my last point, and that's, we're going through tough economic times. Everyone on this call right now knows that. What's the Venn diagram look like between those tough economic times and the FFCRA? Now, like most federal and state leave laws for that matter, there is an anti-retaliation provision in the FFCRA which says, hey, look, you can't take some type of adverse action against an employee because he or she took leave under this law. But that doesn't insulate these people from the realities of the world. You know, sadly, a lot of employers are having to make tough decisions right now with layoffs, with furloughs. An employee who's on FFCRA leave right now, who has taken it in the past, they're not insulated from these tough calls that employers are having to make. So just keep that in mind, that you're free to make the decisions, the tough decisions that you have to make in tough economic times. Lauren, you're probably going to put me on mute if I keep going, so I'm going to turn it over back to you.
No, that's great, Brock. Thank you very much. Really appreciate all of that information. Next, I'm going to ask Josh Bennett to cover the topic of COVID-19 in the workplace.
Thanks, Lauren. Good to be with everybody. Appreciate you tuning in, and also appreciate your support of the BBA. I'm going to talk a little bit about sort of how to deal with COVID-19 and related issues in the workplace as they come up. Brock, in addition to giving a good overview and analysis, the FFCRA mentioned some other statutes, the ADA, FMLA, and these are, of course, ones that you guys know very well. And my portion, sort of handling COVID-19 in the workplace, involves an intersection and a consideration of all those laws, as well as some just practical kind of common sense stuff. And how you approach each situation is going to involve a legal analysis under these statutes, as well as sort of just a practical analysis of what works well for your business. But I thought a good sort of outline for my 10 minutes would be to address some of the questions that I'm getting a lot from clients over the past few weeks. The first of those is, how much medical information, health information can I get from my employees? Can I ask them about, so I can have a handle on who's potentially infected or has symptoms? And the answer is, generally you can ask about COVID-19 and related symptoms, which of course we all know, and they, I guess, have changed somewhat, but the basic ones are fever, coughing, shortness of breath, difficulty breathing, other respiratory symptoms. But the EEOC has come out with some guidance that I recommend to everybody on this call, that addresses sort of how the ADA is impacted by the pandemic. And like in this situation, where you would typically be restricted from asking employees about medical information without some reasonable justification, you're allowed under these circumstances to ask about COVID-19 and related symptoms. Now, this is not a blank check to ask about other impairments. So to the extent you have these conversations with your folks, make sure that you limit it to COVID-19 and those symptoms. And then any information you glean or get needs to be kept confidential, right? Under the ADA, you're required to not only keep medical information confidential, but separate, to the extent it's in document form, separate from personnel files. Another question that I've gotten a lot, and some of you may have implemented a program for this, is can I take my employees' temperatures before they come into work? And of course, this is assuming that these are you have employees who are actually coming on site to work, that you're an essential business, or you're otherwise exempt from the stay-at-home order, and your folks are coming in on site. And the answer to that is yes. It's been authorized by both the CDC and the EEOC to take employee temperatures as a normal practice during this pandemic. Under the ADA, again, this is permissible where it otherwise might not be, as a medical examination. The EEOC's guidance has relaxed the medical examination prohibition for current employees to allow for this. We are recommending some best practices though to follow when you're doing this. If you're taking temps, first you want to be clear that the testing is for COVID-19 and not to detect other impairments that employees may have. You want to make sure that your program's uniform and consistent and avoid any disparate treatment. So it needs to be that you test everyone or some subset based on some objective criteria. But you want to avoid any inference of discrimination there. We were recommending that you test in a private space and in a way that avoids employees congregating or forming lines. I mean, that's, that goes into the social distancing thing, but it also promotes that confidentiality that we talked about under the ADA. A positive test result, or quite frankly, a temperature reading in and of itself is going to be private health information that the ADA would say you must keep confidential. So you want to have your testing set up such that if at all possible, that if you test somebody and they have a positive test, the way you react to that, you don't want other employees to know the identity of someone who's tested positive and been sent home potentially. As far as testing equipment goes, we recommend using non-touch thermometers if possible, having the individual administer the temp check themselves, minimize contact between folks, sanitize your equipment in your area, have a plan for dealing with people who have elevated temperatures, and we'll talk about how to deal with symptomatic employees shortly. Of course, maintain the confidentiality of your test results. And lastly, I would say to those of you who are unionized, if you have a union at your facility, to coordinate with them and make sure your plan is good with them and works within the parameters of your CBA. And also have a plan for dealing with employees who refuse to be tested. Discipline may be appropriate in that circumstance, or you may choose to send them home and give them a certain amount of leave. In any event, you want to be consistent with that. Okay, so what do we do if someone has symptoms? This is probably the main question that we get, and again, a lot of this depends on sort of your business and how you can practically respond. But from a legal standpoint and a best practice standpoint, we think the best protocol is to send the person home first and foremost. If someone's been symptomatic, the CDC has recommended that person be isolated from your workforce. So they should be sent home and asked to seek a medical diagnosis or to seek medical attention. At the same time, you can advise them of any leave that may be available to them. Brock talked about the FFCRA, and if someone's symptomatic and sent home to seek medical help, they would most certainly, I think, Brock, correct me if I'm wrong, but I think they would qualify for that 80 hours of paid sick leave if the FFCRA applies to your business. At the exhaustion of that, if they remain out that long, you can consider whether to allow the use of any paid time off or vacation time. I'll just say that most of our clients and most of the businesses out there that we've been interacting with and hearing from have been pretty flexible or lenient, however you want to say it, with their leave and paid time off policies, allowing folks who are out for COVID-related reasons to have that time, both as sort of job protected leave and as paid leave where it's available. What about the FMLA and the ADA in that circumstance? When you have a symptomatic employee or even an employee who has COVID-19, The answer to whether FMLA is triggered depends on whether they have a serious health condition, right? Everybody who's been involved in the FMLA knows that is a defined term in the law, and it means a condition that either requires inpatient care, right, hospitalization, or continuing treatment, which is, a period of 3 or more days incapacitated, unable to work, and under the care of a doctor. We've all heard about cases of COVID-19 that are severe, that require hospitalization or some of this kind of continuing treatment and incapacitation. In those cases, they might very well qualify for FMLA leave. So you could designate it as such, and it would run against their calendar entitlement. But they would also have that benefit of the job protected unpaid leave that FMLA provides. Now, a lot of the cases though, where the symptoms are milder and you treat by resting at home and taking over the counter drugs, those aren't likely to qualify for FMLA leave. Similarly with the ADA, which would provide potentially unpaid leave where none is otherwise available. It's going to depend on whether their condition qualifies as a disability, right? A substantial impairment of a major life activity, breathing, working, other daily life activities. But sort of like with FMLA, typically temporary transitory conditions like the flu or a mild case of COVID-19 perhaps, they typically don't qualify as disabilities. So it wouldn't be triggered in that case. I will say though, to be very careful in how you're treating symptomatic folks or folks that are high risk, right, susceptible because of age or a pre-existing condition. Be careful how you treat them because you might trigger the ADA by regarding, quote unquote, regarding them as disabled or perceiving them as such. Y'all have heard that term before. And that's why we recommend having protocols in place for how to deal with each situation. So that way you can fall back on your protocol and you're not making value judgments based on some perception of somebody's condition. So you've sent someone home, you've considered their leave options. What do you do next? We recommend, and consistent with the CDC and OSHA guidance, we recommend a prompt investigation of that person's sort of sphere of contact and physical area of contact. Where have they been in the workplace and with whom have they interacted closely recently, right? So you can make a judgment as to who else needs to be notified and potentially sent home if the person ultimately tests positive for COVID-19, then you may have people who have had first-degree exposure that need to be isolated too. So conducting that investigation is important. It should involve a conversation with the symptomatic employee over the phone if possible. But if you do it in person, obviously the interviewer needs to take the right precautions and wear the right protective gear. It goes without saying, any of the areas you find where they have been should be clean and sanitized. Again, CDC provides has a wealth of guidance on how to clean and sanitize work areas. And then the question is, once they're home and they're out, when can they return to work? What do we need? Can I require them to bring a doctor's note? Should I require them to bring a doctor's note? You can require a COVID-19 positive employee or a symptomatic person to bring a doctor's note if it's consistent with your normal return to work practice. but understand that it may be hard under the circumstances for employees to get into doctor's offices, especially if they don't have a very severe case or their symptoms are not severe. They may not be able to see a doctor due to the kind of the overwhelming nature of this on the healthcare system. But the good thing is CDC's released some guidelines, and you guys can all go see what those return to work guidelines are. But for employees who are symptomatic but not necessarily positive, they're recommending that they be able to return to work after they have a negative test result, and that they have 3 days symptom free. If a test is not available to that particular employee, in addition to 3 days of being asymptomatic, the CDC recommends at least 7 days from when the symptoms begin. If the employee does test positive, there are recommended conditions for returning to work for both when you can have a test and when you cannot. If the employee can get a test, then the CDC recommends that they have 2 negative tests at least 24 hours apart, and that their fever and other symptoms have resolved. If there's no test,
Just one more minute.
okay, thank you. If there's no test available, then they recommend that the employee have 7 days since the symptoms appeared, that the symptoms have resolved, and they've been at least 3 days without a fever, without the use of medicine. Okay, so that's kind of how to deal with an employee who has symptoms. What if they're exposed either to a family member or to someone at work? The CDC is recommending to someone who's exposed to COVID-19, 14 days of quarantine. If they can get a negative test result, that's great. If not, they're recommending at least 7 days without symptoms. We recommend doing the same investigation that you do with someone who's symptomatic. The leave that's available for them, the FFCRA would probably not apply unless they are actually caring for the family member who they've been exposed to. So, a lot of their leave is going to be dictated by your policies. They're not likely to qualify under FMLA again unless the family member that they've been exposed to has a serious health condition. And even if a family member has a condition, they're not likely to trigger the ADA. I appreciate you guys listening. Sorry if I ran over, Lauren. And please get in touch with us if we can help you in any way.
Great. Thank you so much, Josh. I appreciate that. Now we're going to go to David Block, who's going to cover navigating furloughs, layoffs, and unemployment.
Thanks, Lauren. Thanks, everybody, for your attention and allowing us to speak with you today. So my topic, dealing with layoffs and furloughs and the interaction they have with unemployment, is something that many of you have probably already been dealing with, but we still think it's a timely topic because there's continued evidence and indications that there's going to be second and maybe more waves of layoffs as the ripple effect of the business downturn affects other businesses. One thing that I try to do, number one, is I talk slow. So I bet it's going to be hard for me to cover what I want to talk about in 10 minutes. So I'm going to try to stay at a pretty high level. But another thing I do is try to simplify things as much as I can so that I can understand them. And essentially what my topic deals with is what options are available to an employer who, because of lack of work or revenue or lack of funds, can't keep their workers engaged like they did before the pandemic. Layoffs, which are terminations, are obviously an option. Furloughs, which we could get into the word history of what a furlough is, but essentially in the US, when people mention furloughs, it's essentially an unpaid time away from work where the employment relationship does not end, but the employee's not working for a period of time. That's an option. But what I wanted to start off with in talking about these topics was sort of what we're getting a lot of is questions from employers that don't want to lay people off. They want to explore their options to laying people off. So they get questions about, we're getting questions about, can we cut our employees' pay? Can we cut our employees' hours? Can we send people home for a period of time, essentially furlough them? Can we take exempt employees under the Fair Labor Standards Act, your salaried employees, can we turn them into hourly employees and cut back their hours in a week? The general answer to all those questions is, yeah, you can do it, but you need to have counsel guiding your way so you don't step into any of the traps. And I'm going to go over these things in a little bit more detail. Can you cut an employee's hours or their rate of pay? The answer is yes. For Alabama employees, Alabama law doesn't have a lot of specific requirements about wage and hour requirements. So we deal with the Fair Labor Standards Act, the FLSA, and the FLSA makes a distinction between exempt employees or salaried employees, exempt from overtime, or hourly employees that get paid by the hour. If you cut the pay of an exempt employee, the issue becomes, are you wanting to lower their salary, or are you wanting to convert them to hourly and pay them a lower rate on an hourly basis? If you're going to cut their salary, as long as the weekly salary remains above the federal minimum, which currently is $684 a week, then it's fine. And under the general rules that apply to exempt employees, if they work any hours in a week, generally speaking, they're entitled to their pay for that week. If the idea is to convert them to hourly so that you can control the amount of time they're working and the amount of time they're getting paid for, that's something that you can do. It makes me nervous, frankly, and I know that John Holmes and Josh and I have talked about this in the past, because you ask 10 different lawyers, you probably get 9 different answers, but it's something that you can do, and it's something that we're helping clients do in certain situations, converting exempt employees to hourly. The regulations allow for it as long as you're not doing it frequently or in an attempt to avoid what the Fair Labor Standards Act requires you to do. But what makes me nervous, and it's especially in a situation where the basis for claiming that an employee is exempt to begin with is sort of questionable. For example, if you're not real clear that somebody is clearly exempt, then I think anytime you monkey with how you pay them, it could come back later on as an argument that what they really were doing wasn't really white collar work. But having said that, you can do it. I recommend that if you convert exempt employees, either way, from either lowering their salary or converting them to hourly, either way, I recommend that an agreement be put into place. And I don't mean a fancy agreement. It can be along the lines of an offer letter or an acknowledgement page that just goes into the reasons why you're doing this, and that and your lawyer can help you with the wording, but essentially help protect against an argument that you're changing the essential duties of the job so that it's no longer an exempt position when things go back to normal. One thing that we've been talking with some clients about is some clients are wanting to do this so that they can help their employees who are going to be working a partial work week get unemployment on top of their partial work week. And each state essentially allows for partial unemployment claims. And I'm going to talk about that more in a minute, but that's one reason why some employers are trying to go the hourly route, so that they can make sure that there's an amount of time that their employees are getting paid for. But when you combine that with eligibility for unemployment comp and the $600 enrichment from the federal side that they're trying to keep their exempt employees whole. So that might factor into it. Generally speaking, my preference is, if you can't tell, is not to mess with the hourly and to try to cut their salary to $684 a week if that meets your business needs. If an employee is hourly, you can pretty much cut their pay, cut their hours as much as you want to. As long as you're meeting minimum wage requirements and you're paying them overtime if they do work overtime. By the way, if you convert your exempt employees to hourly, then you have to comply for the period of time that they're hourly, you have to comply with the record keeping requirements. They have to keep up with their time, et cetera. So make sure you follow that if that's something you're interested in. The bottom line is, when you're talking about your employees' hours or the number of hours they're going to work in a week or their rate of pay, you ought to be guided most importantly by your business needs. And once you know what your business needs are, what your restrictions are, you can work with your attorney and essentially come up with a method that complies with the necessary laws. By the way, I'll mention this again later when we're talking about layoffs, but the WARN Act, and I'm from West Alabama, and I tend to put extra syllables and things. I'm not talking about the Elizabeth Warren Act. I'm talking about the WARN, W-A-R-N Act. It can be triggered if you cut your employees, if you cut sufficient a number of employees' pay by 50% for 6 consecutive months. So that's something to think about. Next, in trying to avoid actual layoffs, employers are asking, can we send people home? Can we, I don't have enough work for this particular group for part of a work week or for a short period of time, 2 or 3 work weeks. Can I send them home? Answer again, yes, you can. It's actually a good way of trying to preserve your relationship with your employees. If you're trying to avoid them, cutting the cord and them going off and not being able to attract them back, it's a good way to keep that relationship going. It can trigger unemployment for a short period of time, and that applies also when employees have cut hours or cut salary. Basically, if an employee is not making what they were before because of cut hours or being sent home or reduced salary, Alabama allows for what's called partial unemployment claims. And partial unemployment is when somebody has either lost hours, lost pay, and they meet the requirements of employment loss under the Alabama unemployment comp rules. Back into March, the state came out with some recommendations and instructions to employers that in light of COVID and people losing employment, that they wanted to expedite the process to allow people to get paid. And they really are encouraging employers to file partial claims on behalf of their employees. And they set up this portal on their website and a procedure that I'm getting feedback from some of my clients that they're trying to do that and they're running into problems, which is to be expected because the unemployment comp office is really overwhelmed right now by the number of claims. But the idea is if you expedite, if you assist your employees in making their claims for unemployment comp, then essentially you're going to get forgiven or not charged the experience rating. There's a cost associated, as many of you know, to unemployment comp claims by your former employees, and those charges are being waived indefinitely by the state, especially if you follow their recommendations and assist employees in filing claims. And if you can't file the claims for them, not opposing the claims when the employee raises them. And specifically, there's a procedure waive. Many of you are probably familiar with the form that you get from the state when somebody files for unemployment, and you go into the reasons why they're not working there anymore. Basically, they want you to waive the right to fill that out. But what's interesting is when you waive it, you send an email to them and say, I waive it, and they still send you the form. So there's some confusion out there about it, but make sure you waive the right to assist your people in getting the unemployment. There's also an issue with partial claims that as long as an employee is eligible for at least $1 of compensation under the Act, then they're allowed to tack on the $600 additional from the federal funds. And so if there's ever any situation where one of your employees has reduced work or reduced hours or sent home, always encourage them to apply for unemployment to see if they're eligible for any, because if they're eligible for $1, they can get $601 a week, and that's obviously very helpful for them. One thing that applies to cutting pay, cutting hours, sending home is make sure that if you do it across the board as much as possible, either all your employees or a whole department or a whole subdivision of your operation. Because if you get into the business of saying, I'm going to send, there's 5 guys in this group or 5 people in this group, I'm going to send these 2 people home and not these others, you're setting yourself up for an argument that, you selected them for some improper reason. So, so try to do it across the board. And if you can't do it across the board, then really think through the reasons why you're doing it and document the legitimacy of those reasons. I don't know how I'm doing on time there, Lauren, but
about 1 more minute.
Okay. Well, I've covered 1/3 of my outline. If you do a layoff, let's say you can't do any of the things I talked about before and you're doing a layoff. One thing to look at is if you have more than 100 employees, you may be subject to the WARN Act, which essentially is a federal law that gives employees the right to have 60-day notice in advance of a plant closing or a layoff, mass layoff. Very complicated act, a lot of different definitions. It can be very difficult to follow. But basically, the question that we're working with clients mostly about deal with whether or not the WARN Act even applies, because a certain number of people have to be terminated. There has to be an employment loss to a certain number of people. And if the layoff is intended to be temporary, less than 6 months, then there's a good argument the WARN Act isn't triggered. And there's some other definitions that you can challenge if you're looking at doing a large layoff. One thing I'll say, and I'm just going to keep talking until Lauren just cuts my mic off, but one thing I would say is at the beginning of this, when people were making WARN Act decisions about whether they needed to give notice or not, a lot of people were taking comfort in 2 exceptions to the 60-day notice requirement that the Act allows for: unforeseeable business circumstances and natural disasters. Clients were relying on that, lawyers were relying on that as grounds to not give the notice. That may have been available back then, more so than it is now, because it's not a surprise anymore. And so you can't be cavalier about making these decisions anymore. And so I would just caution you to carefully analyze that issue.
That's great.
One more point.
Okay.
Can I make one more point?
Okay.
I want to address something. What happens if somebody is off work or you've laid them off and you're trying to call them back and they just don't want to come to work? They're scared of the virus. They want to stay home and earn unemployment comp. What do we do? I actually have been getting that question a lot. And the bottom line is, if one of your employees, if you have work for them and they don't want to do it and they're not entitled to any of these paid sick leave categories, or if they aren't eligible for FMLA, ADA, or some other leave, then if they don't want to come to work and you have work for them, you don't have to pay them. And potentially you can fire them if they don't come to work. If somebody has been laid off and you're trying to bring them back and they don't want to come back, again, for the same reason, they're just scared of the virus, then they may lose their eligibility for unemployment comp. Thanks,
That's
Lauren.
great. That's great. David, thank you very much. I really appreciate that. Now we're going to turn to John Holmes, who's going to cover the last two topics. One is mental health and wellness for remote workers, and then recovery and return to work.
Thank you, Lauren. The pace of this pandemic took many employers by surprise. Many decided to send large portions of their workforce home without any experience working remotely. And, Maynard Cooper, we're dealing with this firsthand. As you can see, all four of us are participating in this event from our homes. And so there's this sudden shift like this is not an easy transition for everybody. And you couple that with fear in general about the disease or loss of employment or just the general uncertainty of what we're all facing. It can take a toll on even the most well-adjusted employees. So that employers also don't necessarily have a good handle on an employee's baseline. We're not in the habit of getting into employees' personal business and family situations. And so there can be a lot going on behind the scenes, literally in the camera behind the scenes, that we're just not used to dealing with. And the mental health professionals right now are focusing a lot on isolation. This can lead to depression and anxiety and increased use of alcohol and drugs. And so this is something that you have all your employees home. They're not accustomed to working from home. They may not be well equipped to work from home. They don't have experience doing that. It can be a challenge because we just don't know how long this is going to last. And for many of us, the workplace is social. We have friendships, we have camaraderie. You kind of take that for granted, and looking back on that. But right now, being able to get together with your coworkers, even the annoying ones in person, is something that we miss. Many businesses count on productive teamwork and in-person collaboration to get their work done. So, what are some of the things that you can do as an employer to combat this concern of isolation? Well, first of all, I think, there are some businesses that do this well, and this is part of their business model, but most it's not. And for those who are not accustomed to having a large part of their workforce work remotely, you need to understand that remote work is just different. It's a different kind of work, and you need to set appropriate expectations for your employees as well as your business. How are you going to measure productivity for somebody who is working remotely from home? Obviously, if you have a sales-based organization, you can still measure things by sales, but for other businesses, it's not as easy to do that. How many Tiger King episodes can a person watch in a single day? Is that going to be your measure of productivity? So you need to understand it's going to be different, and you need to tolerate the fact that it's going to be a little bit different. So what are some of the things that you can do to set expectations? Well, number one is to have a remote work policy. So a lot of employers don't have this. They resisted remote work or teleworking, even though there's a framework under the law where that's an option for reasonable accommodation for some people. A lot of companies don't do this. And so having a good remote work policy that affirms what existing policies still apply, provides for timekeeping obligations, both for, primarily for hourly folks, but salaried non-exempt folks as well. Describes what the workday is going to be. What do you expect folks to get done from home, and when should they do it? Obligate communication. You want to make sure that your employees are staying in touch and doing their part. What is their workspace setup going to be like? Who's providing the equipment and technology support? Security issues that are related to that. Believe it or not, there are workers' compensation issues with remote workers. If somebody falls, in their home while they're working remotely, is that covered by workers' comp. I mean, we're going to see these kinds of things by enterprising plaintiffs' lawyers that are going to push the envelope here. In addition to having a good remote work policy, communication obviously is critical. You want to have quality communication with your folks, and keep in mind that, you know, email and text message is generally a poor substitute for an in-person meeting or even a phone call. So a lot of companies are going to conference calls, regular video conferencing. Those of you who are on this program obviously know how to use Zoom. That's become very popular and something that our firm has adopted, but there's no substitute for putting your eyeballs on an employee. You can get a better sense of how they're doing, and importantly, pick up on any warning signs of problems or things that they have going on. In addition to that, you know, how you communicate with employees about, you know, you want to be sincere, you want to be transparent, you want to demonstrate empathy, understand that there's a challenge with what we're facing and that we're all going through. You want employees to develop a routine and make sure that they are aware of EAP support and health benefits that you have for them. And don't forget about your managers. You know, there's increased stress for additional responsibilities. There may be different, you know, this is different for them as well. And so pay attention to your managers to make sure that they understand what the expectations are for them. I'm going to switch to the recovery and the return to work, because this is something that everybody's thinking about. Businesses are trying to plan for. It's a crystal ball. It's hard to guess. The issues are political. They're medical. They can be industry specific. In Alabama, we have some expectation that we'll hear by the end of the month whether this stay-at-home order is going to continue into the month of May, or whether companies will be able to bring back employees. Regardless of when this happens, social distancing is going to be the new normal. Testing is really the key issue before people are allowed to come back to work. If you look at any of the articles and comments being made by business leaders, until we have some baseline of either whether people have been exposed to this or whether they're at risk, it's going to be hard for employers to give the all safe signal to their employees. You know, under OSHA, you have an obligation to provide a safe workplace, and sanitation and cleanliness of facilities are going to be really important, both for your peace of mind for your employees, but also from a liability standpoint. You know, Josh mentioned the CDC guidelines earlier, and we're advising our employees to follow those wherever possible. That's going to be a good defense. We did what the government told us to do as you're dealing with these various issues. And if you don't do it and you have a problem, you have an employee sue you or a third party sue you because you weren't following CDC guidelines, you're going to have a hard time explaining why not. They're readily available, and it's kind of the baseline that people are using. Things to think about when you start bringing employees back. What kind of equipment are we going to have? Are we going to have masks? Are we going to require masks? Who's going to provide those? Are we going to implement temperature checks? Josh mentioned that earlier. A lot of clients are doing that now. But what happens if you have a remote workforce and they're not back and you want to bring them back? Or are you going to start taking blood tests for antibodies? Are those tests going to be available? Alternating schedules, bringing people back where you make social distancing easier. This is the kind of planning that you can do now as you're working through the decision point to bring people back at work, either all at once or in a staggered format. You know, again, we talked about this earlier, and the team mentioned this earlier. You have these legal issues and compliance concerns surrounding, you know, privacy of medical information, OSHA compliance and the like, but, you know, there's a reputational thing to consider as well. Am I rushing my employees back too soon? Do they think that I'm not as concerned about their safety? Are we making them come back when they're not ready? Some employers are considering kind of an optional remote work continuation and let people come back at their own schedule when they're ready. These are things to think about, you know, just along the same lines of being flexible, working with your folks and showing them that you care. You know, how you treat your employees during this time and when you are asking them to come back to work in an ongoing, you know, public health issue is going to be something that they remember. I think there's an opportunity to create some loyalty here with your employees. And we're seeing that with our clients. Most of our clients that we're dealing with are really bending over backwards to do the right thing. And I know that the investors of the BBA want to do the right thing for their employees. So would encourage you to continue to participate in programs like this. Reach out if you have questions, and we are standing by, ready to help.
Great. Thank you, John, very much. That's all of us has been some great information. I'll tell you, we had nearly about 100 people on the meeting today, so you can tell that it is a really important topic that people want and need to know more about. So thank you to our experts from Maynard Cooper and Gale, and thank you to everyone who joined today. We hope you're walking away with some really valuable information. A reminder that both the Birmingham Business Alliance and the Maynard Cooper and Gale websites maintain robust resource pages. So check those out for more information. And if you need any clarification or have a follow-up question, go to the Birmingham Business Alliance's COVID-19 resource page and hit the Ask a Question tab to submit a question. We'll be happy to respond in a rapid manner. So thank you again to our panelists, and thank you for everyone for joining.
Thank you, Lauren.
Thank you.
Thanks.